It's not so important how you feel. What's important is what is the issue that's brought you to court. In other words, what paper got you into court? What happened? Well, the first thing is read the heading of your document or the motion, or the heading of the document or motion filed against you. That will tell you what the issue is before the court. So there's like, say, a motion to set aside judgment. Okay, well, that's what you're there. You're there to either hear or defend against somebody wanting to set aside a judgment that went in your favor, or you want to set aside a judgment that went against you. At either rate, know and focus on the matter that got you there. What is the moving document that got you to the proceeding? What are the facts? The facts tie in, the facts as it relates to the paper that got you in there, and after you read the heading. What facts have you there? Not how you feel, what's in the four corners of the document, and then there could be some things that may not come into the four corners that may be relevant or relative to whatever side of the coin that you may be on. Pace yourself. Listen, never be in a hurry to get the situation resolved, or in such a hurry to get the situation resolved that you overlook something that's extremely important. Let's not, we'll bring up the objections a little bit later on. But again, pace yourself. Don't be so quick to want to respond, especially if you're pro se. Your attorney, if you have one, he'll definitely school you or prepare you for court before you get there. At least he should, or she should, before you get there, to learn how to pace yourself when it comes to responding. Particularly if you happen to be in a situation where you're going to be examined by opposing counsel. Avoid being distracted. When you get ready to prepare for this, your court hearing, you need to find yourself some sort of quiet space or place, and not like a movie, but a quiet place to get your thoughts together so that you can have the best representation, either if you're doing it yourself or even with your attorney. Focus on the things that he's going to talk about or she's going to talk about, and let that be the only thing that's on your mind, so that when you do get inside the courtroom, you have the capacity to stand on your square. Don't get running and chasing, because a lot of times when you run and chase, the other side knows you're running and chasing, and they're going to position you so that they can go ahead and win the case or take you out of the situation. This is always chess, not checkers. Preserve your objections. And this is always important. If you have an attorney, he should do that. If you don't think he's doing that or she's doing that, make sure you say, hey, listen, let's object to that. We don't have, what they say doesn't make any sense. And if you don't preserve your objection, you're going to be in trouble, because if you don't preserve your objections, you're not going to be able to get ready for the next phase of the case. And I say, tell everybody, always have a good court reporting agency. Now, the ones that I use here, and if you have a Zoom proceeding, wherever you are, they can probably help you out there. But I use Richard Lee Reporting here out of Tampa. They've done, in fact, every one of my proceedings, I've used them. Unless the state or whoever, well, actually it was the state, or actually I think in my auto negligence case, they use somebody else. But every time it's me, and I always take a court reporter to courtroom meetings, particularly since I've started to kind of understand how important they are. So for the last 2 or 3 years, I've been using Richard Lee Reporting. They also show up for me in person. Now, depending on where you are, they may not be able to show up for you in person. And I don't know if he has anybody that he would refer you to. But if you want to know anything more about it, call my man Warren. That's where they are. In fact, that's where I did my deposition of the driver that hit me in my auto negligence case, right there at 100 North Tampa Street in that suite. And give him a call. Good guy. Warren is the greatest as far as I'm concerned. He's definitely helped me out, even when it comes to having adequate transcripts for the writ of prohibition that I'm actually working on. Also, in my auto negligence case, I actually did a video deposition. So if you all want that, I can probably get that to you as well. But I went to Casey Video Depots, or Matthew. His wife is the one who's actually the one who did the actual recording, physical recording. But you can get in touch with them right here in Largo, right there in Largo, Florida. Their main office. I just called them and they showed up for me. In fact, at Richard Lee Reporting's studio or office to do their deposition. They were there also, and they gave me some leeway. I was a little bit late getting some funds to them, but at any rate, they showed up when the so-called expert witness and my doctor, which is odd, we'll get into that some other time, didn't show up. So, but hey, listen, they're always there and they do good work for you. Going back to preserving your objections, the reason I say this is because you have to remember the appeals process. The appellate courts aren't there. They're not going to be, they're going to look at the record. So there's not going to be an audio. They're going to look at the transcripts. Whatever is not raised in the trial court, or not going to say whatever, most of the time if you don't raise an issue in the trial court, you lose that any arguments come appeals time. It's like a waiver. And what you do not want to do is to lose your case because of some technicality that could have been caught by yourself or your attorney. And the other reason for preserving your objections is that it keeps you from getting discouraged. Because a lot of us get down, well, I should say as a pro se, and some of the people I've talked to, when it doesn't go your way the first time, we tend to say, well, forget it, let it go, I can't win anyway, everybody's corrupt, it's always going to be something else. I don't have the successes I have if I would have quit the first time something didn't go my way. Heck, I can't remember any of them really where I just walked in and they just said, we're not going to hit. Well, maybe twice, and that's only because it was just so glaring as to what was going to happen. And it may also have happened because I've already developed this reputation for fighting. So that may have benefited me. Let's see. Make your objections timely. So if there's an issue, make sure you object. You give your objection. Even if you don't know the reason for the objection as a pro se, just say, well, object, and then just state it, and then you get a liberal construction when the appellate court gets it in most instances. Your attorney will be skilled, so if you happen to have an attorney, he or she will be able to make objections and hopefully raise valid objections that will help preserve your position in the event that the trial court rules against you. And by the way, do not argue, I guess it's funny coming from me, do not argue with the judge or hearing officer, because that in some ways will kind of jumble the record.